We are considering two nominations, Hampton Dellinger to be the Special Counsel for the Office of Special Counsel, or OSC, and Henry Kerner to be a member of the Merit Systems Protection Board, or MSPB. Welcome to each of our nominees and to your friends and family members who are joining us here today. And thank you for your prior public service and your willingness to fill these two very important positions. OSC and the MSPB are both small, independent agencies that help build a more effective and accountable federal government. In particular, both are essential to protecting whistleblower rights. Federal employees must be able to report waste, fraud, and abuse all across government without the fear of reprisal. Whistleblowers have exposed serious safety shortfalls, wasteful spending, and corruption. They are indispensable to the oversight work of Congress and the Inspector General. The Special Counsel is the chief whistleblower advocate in the federal government and is responsible for safeguarding whistleblower rights. OSC investigates whistleblower disclosures and prosecutes instances of retaliation for vulnerable employees. In addition, OSC helps to ensure that the federal government is free from improper partisan political activity and protects our service members and veterans from employment discrimination. Mr. Dellinger, as you know, independence is critical to the success of the OSC, and I appreciate the commitments you have made to leading OSC in a nonpartisan manner if confirmed. And I look forward to learning more about your experience as well as your vision for this office. The Merit Systems Protection Board is an independent quasi-judicial agency dedicated to upholding the merit systems principles at the very heart of the federal civil service. The bipartisan three-member board evaluates cases of whistleblower retaliation and other violations of civil service laws. The board also conducts government-wide studies of important civil service issues and provides oversight of the Office of Personnel Management. Last year, the Senate confirmed 3 MSPB members. Before that, the board was left without a quorum for more than 5 years. These unprecedented vacancies led to an immense backlog of approximately 3,800 cases. I'm grateful for the hard work that the MSPB has done to resolve a significant portion of this backlog, providing long-awaited resolutions and relief for many federal employees. That said, there's still a whole lot of work to be done. Mr. Kerner, your confirmation would give the MSPB its full complement of board members and allow it to carry out these essential responsibilities. And I look forward to hearing more from you today about how you plan to approach this new role. Each of these nominees will help our federal government remain accountable, efficient, and effective. And I look forward to further discussing their plans for each position. It is the practice of this committee to swear in witnesses, so if each of you would please stand and raise your right hand. Do you swear the testimony that you will give before this committee will be the truth, the whole truth, and nothing but the truth? So help you God. You may be seated. Our first nominee, Hampton Dellinger, is most recently served in the Department of Justice from October 21 to June of 2023. As an Assistant Attorney General overseeing the Office of Legal Policy. During his tenure, OLP updated guidelines for the support of crime victims, contributed to the national strategy to combat human trafficking, and played a key role in implementing public safety policies such as the bipartisan Safer Communities Act. He has previously served in the North Carolina Department of Justice, the Office of North Carolina Governor, and in private practice. Dellinger holds a JD from Yale Law School, and I'm proud to note that he received his undergraduate degree from a really wonderful, great university, the University of Michigan. Mr. Dellinger, you're recognized for your opening statements.
Chairman Peters, Senator Hassan, Ranking Member Paul, and senators of this distinguished committee, thank you for considering my nomination to head the Office of Special Counsel, OSC. Each day, millions of federal employees interact, reach decisions, and take action. We are all indebted to these honorable civil servants, as so much of this workplace conduct is lawful, professional, and in the public interest. But each year, there are several thousand complaints made to the Office of Special Counsel about governmental conduct that is not appropriate. And we also owe thanks to everyone who blows the whistle on government misconduct, because they do so with great courage and, regrettably, too often find themselves at professional peril. But our gratitude is not enough. Federal government whistleblowers deserve and are legally entitled to robust protection from retaliation. Simply put, the branch of government that executes the law and enforces the law must obey the law, always. If confirmed, I will take every complaint made to OSC seriously, every single one. And my overriding goal will be to contribute to greater trust in government, including by protecting whistleblowers vigorously. To earn such trust, I promise to act independently, just as I have done throughout my 30-year legal career. In North Carolina, I sued the administration of a governor I admired and had previously worked for because I saw taxpayer funds being misused and wasted. At the United States Justice Department, I advocated for scientists and not lawyers to lead on forensic science issues. And I raised privacy, civil rights, and civil liberties as vital considerations in surveillance and other law enforcement operations. At OSC, independence to me would mean ensuring that all federal workers, no matter what they disclose or about who they challenge, receive the legal rights and protections they are guaranteed. If confirmed, I will work with my OSC colleagues to vindicate these rights and protections. We will do so independently, even-handedly, without regard to politics, and 100% consistent with the mission and mandate Congress has given the agency. I've worked with, advocated for, and provided trusted counsel to whistleblowers throughout my career. They were key to the Medicaid fraud cases I oversaw in the North Carolina Attorney General's office, to the False Claims Act case I filed on behalf of a key TAM plaintiff, and to lawsuits and investigations I've handled and led for years. I strongly agree we should have an annual designated Whistleblowers Day to acknowledge their inestimable contributions to government accountability and transparency. And if confirmed, I will make sure to ensure that federal government whistleblowers are respected and protected every day. OSC also enforces the Hatch Act, a law that demands nonpartisanship in executive branch activities. I know the Hatch Act well. I taught it as a law school instructor, and I followed it to the letter as a public official. I am prepared to enforce it vigorously and even-handedly. I also believe deeply in another core mission of OSC, ensuring that federal workers also serving in the military do not face job-related setbacks when returning from active duty or training. I made promises to the U.S. Senate when in 2021, you confirmed me to be an Assistant Attorney General, heading up the Office of Legal Policy. I kept my word. Senators asked me not to impose litmus tests on potential judicial nominations my office vetted. I didn't. I was urged to make sure that background investigations of nominees were thorough and surfaced every relevant issue. I did. I was told not to be a partisan. I wasn't. I'll end with my family. My late father, Walter, served in the executive branch in the 1990s. My late mother, Anne, also worked for the federal government. She was with the FBI in 1979 and 1980, and while there, she had the courage to call out gender discrimination she witnessed. I am proud of my mom's distinguished career, as well as my dad's, and I deeply admire the teaching and scholarship of my wife, Jolynn, a privacy expert at Duke Law School. Our son and our daughter are both first-year law students, and I hope they're studying for exams. I know the most valuable possession I can give them is the good name my parents left for me. As a lawyer, a husband, and a father, I can assure the committee that I will always adhere to my legal and ethical obligations and properly discharge my duties. If confirmed, I will view serving as special counsel as a high honor bestowed upon me only temporarily, and one that I must safeguard as a vital public trust. Thank you for your consideration. I want to thank Henry Kerner, who ably upheld that trust during his recently ended tenure as special counsel. Acting special counsel Karen Gorman is doing so as well. I'm indebted to and thank them both. I'm honored to be here, and welcome your questions.
Well, thank you. Our second nominee, Henry J. Kerner, as was mentioned, most recently served in the role that Mr. Dellinger is nominated to fill. So he served as a special counsel of the U.S. Office of Special Counsel and served in that role from October of 2017 to October of 2023. During that time, he helped increase OSC's responsiveness to whistleblower complaints and restructured the office's programmatic units to improve efficiency. Mr. Kerner has a long career of public service, including as a prosecutor in Compton, California, and a staff member for the House Committee on Oversight and Government Reform. He holds a JD from the Harvard Law School. Mr. Kerner, welcome to the committee, and you are now recognized for your opening statement.
Thank you very much, Mr. Chairman. Chairman Peters, Ranking Member Paul, Senator Hassan, and distinguished members of the committee, thank you for the honor to appear before you today and for the privilege of your consideration of my nomination. I'm honored that Minority Leader McConnell recommended me and President Biden nominated me for the position of member of the Merit Systems Protection Board, which protects the employment rights of federal employees and safeguards the merit system that is foundational to our nonpartisan career civil service. I'd like to start by extending my gratitude to my family in California, my parents Mark and Larissa, who are watching online. They've been incredibly supportive, and I appreciate their continued engagement. I'm also grateful to the late Senator John McCain, who gave me the opportunity to serve as a staff director on this committee's permanent subcommittee on investigations during the 113th Congress. Finally, I want to thank the staff of OSC, some of whom are here today, with whom I've worked over the past 6 years. My former colleagues at OSC are incredibly hardworking, knowledgeable, and dedicated to the agency's mission. Together, we had to overcome many obstacles, from the COVID pandemic to addressing the agency's backlog, to an extended government shutdown, to 2 Supreme Court cases that challenged OSC's independence. I'm so proud of how everyone not only persevered, but excelled in the face of these myriad external challenges over my term as special counsel. 6 years ago, I sat before this committee to lay out my vision for OSC as the nominee for special counsel. I'd like to briefly recap some of those goals and see what we were able to accomplish during my tenure. First, I wanted to build on the excellent work of my predecessor, now Judge Carolyn Lerner. We achieved record numbers of what we call favorable actions, which include corrective action for complainants and disciplinary action against agency officials found to have engaged in misconduct. For example, in FY 2022, OSC achieved a record 417 favorable actions, nearly 20% above the average over the previous 5 fiscal years. In 2021, OSC was recognized as the second highest ranked best places to work out of 29 small federal agencies by the Partnership for Public Service and Boston Consulting Group. We finished in the top 3 again in 2022 and this year. Second, I said I wanted to implement information technology system upgrades to prioritize caseload efficiency. In 2018, OSC successfully launched our new internal case management system, ECMS, which is considerably more user-friendly than its predecessor, OSC 2000, was. 6 years ago, I also highlighted my goal of addressing how to optimize the intake of cases to provide appropriate response times to whistleblowers. When I first arrived at OSC, I assembled an efficiency and effectiveness working group, which studied OSC's processes and found that OSC could perform more efficiently by improving intra-agency collaboration and communication. Under the resulting reorganization, OSC streamlined its procedures for prohibited personnel practice, PPP complaints, by combining units with overlapping responsibilities and creating one unit to handle all PPP complaints that meet threshold jurisdictional requirements. Fourth, I wanted to increase education and outreach with agency and congressional staff, especially with regard to the Hatch Act and whistleblower rights. It is critical that OSC work with agencies to ensure they receive robust training to prevent violations before they can occur. During my tenure, we dramatically increased training of the federal community, conducting approximately 150 outreach events per year. With regard to the Hatch Act, I'm very proud of OSC's record of even-handed enforcement. A special counsel's term is 5 years, including a potential 1-year holdover, and intended to overlap presidential administrations. This statutory scheme relies on the special counsel's independence, unbeholden to political influence, and free from partisan bias. I relied heavily on the recommendations from OSC's experienced career Hatch Act unit staff, and we enforced the Hatch Act evenly against members from both administrations. In summary, I'm proud of our achievements over the past 6 years, and I'm confident that OSC will continue to be a model federal agency in the future. I now look forward to a new challenge as a board member at the MSPB in the event I'm fortunate enough to be confirmed. The mission of the MSPB is to protect the federal merit system principles, which will uphold the value of fairness, equal opportunity, and non-discrimination within our civil service. If confirmed, I look forward to the opportunity to work closely with the two other members, Acting Chair Kathy Harris and Ray Limon, to protect the employment rights of federal employees and to work down the inherited inventory of cases from the years without a quorum. I also wanted to say thank you to Mr. Dellinger for his kind words in his opener. And of course, should he be confirmed, I wish him nothing but the best and stand ready to assist in any way. Thank you for listening to me, and I'd be happy to answer any questions. Thank you.
Well, wonderful. Thank you for that. There are three questions that this committee asks of every nominee, and I'm going to ask you both to respond just briefly with a yes or no. Mr. Kerner, we'll start with you, and then Mr. Ellinger for the three questions. First, is there anything that you are aware of in your background that might present a conflict of interest with the duties of the office to which you have been nominated?
No.
No.
Second, do you know of anything personal or otherwise that would in any way prevent you from fulfilling and honorably discharging the responsibilities of the office for which you have been nominated?
No.
No.
Lastly, do you agree without reservation to comply with any request or summons to appear and testify before any duly constituted committee of Congress if you are confirmed?
Yes.
Yes.
Very good. Mr. Dellinger, the Office of Special Counsel has around 140 employees, but it's responsible for protecting the whistleblower rights of all 2.1 million employees all across the federal government. So my question for you, sir, is if confirmed, how will you ensure that every federal employee has confidence in OSC's independence and commitment to protect whistleblowers?
Thank you, Senator. The first thing I want to recognize is the fine work that OSC has been doing under former Special Counsel Kerner. He and Judge Lerner really helped, I think, to elevate the confidence that federal workers can have in OSC. I think Congress has confidence in OSC, and OSC has been doing a great job, it looks like, at prioritizing the cases that it will focus on and being really efficient and really effective with the cases before it. So my first order of business is to not disrupt the great work that's being done today, including under Acting Special Counsel Gorman. And that will be my focus. I've worked with whistleblowers throughout my career. I've been a litigator throughout my career. I've been an investigator throughout my career. So those are the core functions of OSC: to investigate, to litigate, to advocate. And it's something I have a lot of experience with, and I would very much look to be a meaningful member of the team.
Mr. Kerner, the MSPB and the OSC both serve important functions when it comes to upholding whistleblower rights and preventing prohibited personnel practices. However, the role of an individual MSPB member is quite different from that of the special counsel role. So my question for you, sir, is if confirmed, how will you approach the transition from leading an office focused on investigating and prosecuting cases to serving as an impartial adjudicator?
Absolutely. The roles are quite different. Not only is the special counsel, of course, investigating these practices, but also the special counsel stands alone, stands as a single decision maker, a single director. So the transition to going to the board will require a different skill set, both in terms of a different role, which is now adjudicating cases. It's a more judicial role, but also working in a board, working with two other members and having that kind of give and take that is required in order to come to hopefully consensus or working on the decisions. I think one thing that's really prepared me at OSC very well for this role is I've always had a very robust discussion, an open discussion process, and people were able to express their views freely. And so I've kind of been a little bit in a judicial role already because I would get opinions from various people and then had to make a call based on that. And so I think that training I will bring with me when that same thing happens in adjudicating cases, obviously a little bit more on the judicial side at that point.
Mr. Dellinger, one of OSC's lesser known but I think incredibly important responsibilities is enforcing the Uniformed Services Employment and Reemployment Rights Act, or USERRA. This law ensures that military service members and veterans don't face discrimination when they're seeking return to civilian employment. Could you briefly describe how you will prioritize USERRA enforcement if you are confirmed for this position?
Absolutely, Senator. And I'm proud of my ties to Michigan, but I'm a Tar Heel. Grew up in North Carolina, and North Carolina prides itself on being America's most military-friendly state. So for decades, my friends, co-workers have been in the military, active duty, reserves, and I've seen them leave the civilian workforce and then come back. And I strongly believe in USERRA, in the protections that Congress has established for members of the federal civilian workforce, to allow them to serve our country, to respect the fact that they have put their lives on the line for America, but then to return with no detriment to their civilian prospects. So I believe there's a sensitivity within federal agencies to the rights that federal employees have when they go on active duty or training. But when issues arise, it's up to the Office of Special Counsel to protect our federal workers who are in the military. And I'm fully committed to making sure that all the necessary resources are available, if confirmed, to vindicate the rights of every single member of the federal civilian workforce who also does double duty on behalf of America in the military.
Ensuring that employees and managers fully understand their rights and their responsibilities, I think it can be argued will help prevent whistleblower retaliation and other prohibited personnel practices before they occur, which is the ultimate goal. Mr. Kerner, are there any outreach or training efforts that you found to be particularly effective during your tenure at the OSC? And if so, or if not, are there lessons that you have learned that you're going to be able to apply to the MSPB?
Yes, Mr. Chairman. The outreach at OSC was very, very important. We did about 150, give or take, in the different year. I know the Hatch Act unit goes and has meetings. I think most effective, since you asked about effectiveness, are meetings that are in person, that allow for engagement. And we did a lot of those. I noticed that MSPB also did a lot of outreach. They've done about 112 meetings, so I think we're quite aligned with them on that. As you say, it is crucially important to teach supervisors and also managers about non-retaliation. And so I think just building on the good work and having a very robust outreach function. OSC has 3 dedicated people to doing that, plus a lot of the line lawyers also go out and do a lot of the teaching. So I think just having an emphasis from the top about the importance of outreach, advocacy, and training is really important.
Well, apart from the agency's adjudication functions, MSPB responsibilities include conducting nonpartisan studies on the federal workforce that can inform policymakers and other government decisions. So, Mr. Kerner, if confirmed, how would you use your role on the board to shape the strategy for these federal workforce studies and the specific topics that they assess related to the health of the federal service?
So MSPB has a plan, actually. So they have an office, I think it's called OPE, that conducts these studies. That office has laid out a plan. It's from 22 to 26. They had about 40 studies that they suggested, looking at 6 different areas. Their proposals go to the board, so the board already approved a lot of them and prioritized a number of them. So by the time I get there, there's already a plan in place. Obviously, the last couple of studies were on sexual harassment in the workforce and on perceptions of prohibited personnel practices. So they're very timely and very important themes. They have, as I said, they have about 40 that they've already prepared, and the board has voted on to prioritize. But obviously, once I come in, I'm happy to contribute my thoughts on this topic as well.
Well, you mentioned some of the future. Do you anticipate conducting studies on the federal government's recruitment, retention, and training practices and how they can be improved? Is that something you would be interested in focusing on?
Yes, and I believe those are already on the approved list from the 22 to 26 time period.
And those are ones that you will focus on?
I think mine would be a recommendation, but I certainly think those should be considered, yes.
Great, good, thank you. Senator Carper, you're recognized for your questions.
Thanks, Mr. Chairman, and welcome. Nice to see both of you. Congratulations on your nominations, and thank you for distinguished careers in the service to the people of this country. As lifelong public servants, you know better than most that our workforce is one of the most important assets, I think maybe the most important asset that we have in the federal government. And the role of special counsel and the Merit System Protection Board is, as you know, critical to safeguarding the integrity of our civil service, protecting whistleblowers and ensuring that all federal employees have a safe and a fair place to work. I'm going to start off with a question, if I could, Mr. Dellinger, for you on the importance of customer service, something I've been interested in forever, customer service. But during your nomination, you've mentioned the importance of improving customer service, something I applaud, and developing a culture at the Office of Special Counsel that makes your resources accessible and available to those who need them. I applaud your commitment. During the Thanksgiving holidays, my wife and I went on a 5-state road trip, and it took us back through my native West Virginia. And we almost drove right by in Beckley, West Virginia, on Harper Road, where Patton's Market used to exist, and was in business for about 30 years or more, owned by my aunt and uncle. The butcher, their butcher was my grandfather. And when you walked into that store, it had a sign that said, "Welcome to Patton's Market, friendliest store in Beckley." And my wife and I visited one of my cousins whose father owned that store, and they found at their home in their garage that sign that used to say, "Welcome to Patton's Market, friendliest store in Beckley." So I'm a big believer in that. As a kid who used to work there a long, long time ago, big believer in customer service. But I believe in improving customer service and making government more accessible to the people that we serve, whether it's expanding access to taxpayers' services, which we deal with on another committee I serve on, the Finance Committee, or improving services at our Division of Motor Vehicles and inspection lanes and all. Our constituents need to know that our government is responsive to them and their needs. And I think the Office of Special Counsel is no different. And while your customers may be whistleblowers or civil service employees, your office has a responsibility to intake complaints efficiently and effectively. My question is, Mr. Dellinger, what would a customer service-oriented culture at the Office of Special Counsel look like to you? And could you just explain for us why customer service is critical in your point of view, and why is it critical to fulfilling the Special Counsel's mission?
Thank you, Senator, for the question and for being here. My first job was delivering newspapers. I always took it to the door. Then I bagged groceries. I would take it to the car. It's something customers.
Sounds familiar.
Yes, customer service is something I grew up with. And particularly as a litigator, you have clients, witnesses, who are facing maybe the most difficult moment of their professional careers when they're in high-stakes litigation. And you have millions of federal workers, but every year you have a couple thousand who see wrongdoing, who see misconduct, and who don't look away. They stand up and say something. And to my mind, every single one of those cases has to be taken seriously, empathetically. You have to look at the facts and follow the facts in the law. And it's difficult with the small agency, a couple hundred, 120, 130, 140 members of OSC trying to look out for 2.1 million federal workers. But the way to do it is to not think about the overall statistics, think about each person as an individual. And as I said in my opening statement, I am committed to taking every single complaint filed with OSC seriously and personally.
Let me, in addition to that, what steps, other steps come to mind that you take to make the Office of Special Counsel and its resources as accessible as possible to any and all who need them? And are there any specific areas of improvement or policies that you're looking to implement?
Well, I would want to, if confirmed, consult with my new colleagues. I certainly admire the work that former Special Counsel Kerner did, along with his colleagues, in reducing the backlog. Obviously, having a quorum at the Merit Systems Protection Board has helped, but there are still thousands of cases pending at the Protection Board. There are a number of cases OSC is still working on, and so I'm committed to being a hard-working part of the team. I'll take on any task to get the job done, and I'm committed to making sure and advocating for OSC having the resources it needs to get the job done that Congress has intended.
Okay, thank you. Mr. Kerner, please welcome. Good to see you. As you know, the Merit Systems Protection Board, you know better than most of us, went nearly 5 years without a quorum, significantly hampering its ability to function and to process cases, and during this time, the backlog grew to an unprecedented level. I'm told of more than 3,500 cases, which is a lot of cases. Justice delayed is justice denied. We need a functioning and effective board to safeguard the civil service and protect our federal employees. In your testimony, I believe you mentioned your commitment to working with your fellow board members to address this backlog. Good for you. Mr. Kerner, as a special counsel, you testified that you modernized the office's case intake system and improve responsiveness and favorable actions on behalf of complainants. Question, can you share with us what strategies you found were most effective as special counsel in improving the office's abilities to be responsive and effective? What lessons did you learn during your tenure?
Thank you, Senator Carper. It's nice to see you again as well. I also delivered newspapers when I was a kid.
Anybody in the room who did not deliver news or bag groceries? We did all the above.
I think the most effective ways that we improved customer service at OSC and also our efficiency was through, as you say, getting through the backlog, being more efficient. We combined some units that had some internal lags, so we eliminated that. So what happened is now when you file with OSC, you get someone assigned, typically a lawyer or occasionally an investigator, within 48 hours. That person is assigned for the duration of the case. So there's no, handing over cases, which delays people having information about the cases. We learned that having more efficiency that way is really helpful. We reduced the backlog by almost 1,000 cases at OSC. I have to give credit to the current board members, Kathy Harris and Ray Limon. They've reduced the backlog from, as you say, almost 3,800 cases to about 1,900, so about half in a year and a half. So hopefully if I'm lucky to be confirmed, I would get in there and help out with that task too, because as you say, justice delayed is justice denied a lot of times.
Thank you. And just in closing, my time's expired. When I used to be governor, when I got to be governor, we're considering changing the state motto. It had been, I think it had been like first state, we're the first state to ratify the Constitution. So you come across the border into Delaware and they say, welcome to Delaware, first state to start a nation. Pretty good motto. Another governor, I think it was Governor Pete DuPont, changed that to the small wonder, welcome to Delaware, small wonder, which is a pretty good one as well. And I toyed with the ideas of new governor, changing it even further to say, welcome to Delaware, the friendly, but you'll get used to it. There you go. With that, I'm going to relinquish my time. Thank you very much. Thank you all for your service. Thanks to see you.
Thank you, Senator Carper. Senator Hawley, you're recognized for your questions.
Thank you very much, Mr. Chairman. Congratulations to the nominees. Thanks for being here. Mr. Kerner, let me start with you. Almost 2 years ago this month, I wrote a letter to the GSA about the Goodfellow Federal Center in St. Louis, Missouri. This was, you might remember, a center where workers had been exposed and children had been exposed in the child care facility to widespread contaminants, including asbestos, lead, mercury, arsenic, and explosive materials, just for good measure. And I wrote this based in large part on your report to President Biden, which claimed that whistleblowers had reached out to your office regarding this issue. I'm pleased to say that since that debacle, the Goodfellow Center has been closed, that its employees have been moved to a safe location in downtown St. Louis. And I bring this up just to say that I appreciate your vigilant work on this because of the work that you did and because of your protection for whistleblowers. We were able to get some relief, much needed relief for the people of my state. So let me just ask you this. If confirmed, what role, if any, would you see yourself playing in continuing to protect whistleblowers who might speak out to federal officials and expose important instances of corruption and abuse like that one?
Thank you very much, Senator. On the board, it's really important that we obviously have an adjudicatory function, so it's a little bit different, but making sure that there's no retaliation, either within MSPB itself, but also making sure that there's B8, B9 cases that are brought, and that those are adjudicated correctly, and that whistleblowers are protected and don't face retaliation. And I think it's from a judicial standpoint as opposed to from an investigatory standpoint that I would contribute at that point.
Yeah, very good. Just in terms of making sure that the whistleblowers don't face retaliation, particularly at MSPB, I mean, what steps do you envision taking to see that that's the case?
So one of the most important steps is you have to communicate that. I know Chair Harris has already done that. I'm aware she's had a yearly speech where she tells managers not to do that. It's also in managers' performance plans. So they get evaluated based on non-retaliation. I, from my own experience, of course, bring a special sensitivity to that because that's what I've been doing the last 6 years. And I also believe in what I call the challenge process. And that's basically allowing people to have a wide swath of opinions that I listen to, and everyone's welcome to express those, and there's no retaliation permitted.
Very good. Thank you for your service on this. Mr. Dellinger, you were at the Office of Legal Policy for how long?
Approximately 2 years.
Yeah, I think I saw you in the Judiciary Committee before you took that job. Are you familiar with this case, Missouri versus Biden?
Not in detail. That was handled, the civil appellate, the Office of Solicitor General would focus on the litigation for the department.
But are you aware of the case and its significance? I mean, do you know what it's about? Do you know anything about it?
I'd be happy to respond to any specific question you have.
Well, I'm surprised that you haven't at least heard of it. I mean, are you aware of the basics of the case?
I would ask that you remind me.
Missouri versus Biden is a case brought by my state against the Biden administration and various agencies of the government, including those who you had some portion overseeing, the Department of Justice, for their coordination with social media companies in censoring American speech. Is this ringing any bells yet?
It does.
Okay, good. Oh, I would certainly hope so. It is, to my knowledge, the first time that a series of federal courts, Federal District Court, Federal Court of Appeals, found that the White House directed the censorship of American speech and directly violated the First Amendment. Now, the court found, among other things, and there are voluminous trial findings here that were then affirmed on appeal in the Fifth Circuit, found that the White House directed these social media companies to take down posts that they didn't like, directed the social media companies to change or alter their censorship practices, that the FBI, that CISA, that the CDC, and a variety of other federal agencies regularly met with these social media companies and coerced them into carrying out the administration's censorship agenda. And that included people in my state who were censored. We had parents, according to the court's findings, parents in my state, in the greater St. Louis area, who had posts about school board meetings that were removed by Facebook. School board meetings that were removed at the direction of the White House and the FBI. I mean, this is really extraordinary. These companies, I should just say, already have too much power. These companies are, in my view, a scourge in this country. But to have the federal government use the companies as their instrumentality to censor American speech is unbelievable. Were you aware of this happening while you were at the Justice Department?
I was not involved in litigation on behalf of the Justice Department.
Were you aware of the actions happening? Were you aware that the White House, the Justice Department, the FBI, CISA, the CDC were meeting with social media companies?
I was not.
What would you advise the White House to do in the wake of this ruling?
Well, I think all Americans and all parties to litigation have to comply with court orders. I know the Justice Department has a litigation process where the Civil Appellate Division, the Office of the Solicitor General handles litigation on behalf of the department. There certainly has been a lot of litigation involving states, including yours. And so, one, you follow the order of the court, and you follow the process on appeal.
But do you think that this is a problem? I mean, do you think it's a problem that the White House, the FBI, the CDC, CISA has been found by multiple federal courts now to have violated the First Amendment with respect to the speech of individual Americans? I mean, does that strike you as problematic?
I certainly believe that everyone needs to follow court orders. So if there's been a court finding and a court directive, then all Americans, including the federal government, need to adhere to the court directive.
Well, do you think it's appropriate for the White House and other members of the federal government to meet with social media company executives and officials and try to coerce them to carry out the speech agenda of the White House? Do you think that's appropriate?
Well, I think what's appropriate is that every federal employee follow the law, respect and honor the First Amendment, don't engage in improper censorship. So to that extent, I agree with you that conduct has to be lawful and constitutional.
Were you consulted at any time in the last 2 years about meetings with social media companies, interfacing with social media companies, policy towards social media companies in any way?
Well, my office did play a coordinating role to combat human trafficking. And so I'm not aware of any specific meetings, but I know we were one aspect of combating human trafficking.
What about combating so-called misinformation, disinformation, malinformation?
Right. I was not involved in that.
And the Office of Legal Policy has given no advice on that at any time, to the White House, to the Attorney General, to the DAG?
No. Again, you've got the Civil Appellate, Office Solicitor General, Office Legal Counsel. That type of issue might have fallen in one of those bailiwicks.
So your testimony to this committee is you were completely outside of the loop on this at all times. You knew nothing about it. You didn't play any role in it. Your office didn't play any role in any of these meetings with social media companies, and you were not consulted about it at any time.
That's correct.
Okay.
Again, other than on efforts to combat human trafficking.
And did that involve any requests to change the moderation policies, so-called, of any of these companies, to your knowledge?
Not to my knowledge, Senator.
Okay. Mr. Chairman, my time has expired. I just want to note again for the record, and the reason I raise this with you, Mr. Dellinger, is you were in a very senior leadership position at the Department of Justice. And this is very serious. It is very serious when the American people can't go online and post about a school board meeting and not have the White House censor their speech. I mean, we're not going to have a democracy if you cannot speak in this country. And it wasn't one issue. I advise you to read the case. It was COVID, it was elections, it was school boards, it was the Hunter Biden laptop story, it was everything. It was anything that the White House did not like, that it would label disinformation, malinformation, who knows what. Anything they didn't like, they would go to these companies, and the companies remarkably just complied. Of course, they coerced them to do it, but I'm sure the companies actually enjoy doing it because they enjoy the power. The problem is the only people who don't have power in this scenario are the American people. They're the ones who get screwed in this. And I can just tell you, if we can't have free speech in this country, we can't have free elections in this country, and we don't have a democracy. And the fact that you were in a leadership position at the Department of Justice while this is going on gives me serious, serious pause. Thank you, Mr. Chairman.
Thank you, Senator Hawley. One last question before we start wrapping this up, and it's going to be to both of you gentlemen. You both have extensive experience working directly with whistleblowers throughout your entire career. So my question for you is, are there additional steps that you think that agencies or Congress can take to strengthen whistleblower protections and create a more open, more non-retaliatory culture all across the government? Are there any things that come to mind that would be helpful for us to consider, particularly as this committee attempts to constantly strengthen the protections for whistleblowers? Mr. Kerner, we'll start with you, and then the last word will go to you, Mr. Dellinger.
Yes, I think the most important thing in terms of strengthening whistleblower protections is a consensus, the bipartisan consensus. And so to the extent that the Congress, the Senate, this committee can find it to collaborate and to agree amongst yourselves on the importance of protecting whistleblowers, because sometimes whistleblowers disclose things that may be inconvenient to one party or the other in power. But if we don't support them in general and in principle, then it just becomes another political football. And so I think that's the important thing, and that then trickles down to agency leadership, holding the secretaries, the cabinet secretaries, the leaders of agencies accountable for ensuring that whistleblowers are protected. One of the things I did when I was there, I went and met with a lot of leaders. I met with 3 VA secretaries, the current one and the 2 prior predecessors, in terms of respecting whistleblowers and the culture. VA is one, as I like to call it, our #1 customer. And so they obviously have a lot of whistleblowers, and protecting those whistleblowers and making sure 2 things. One, that they take seriously what the whistleblower reports and make sure that they follow up. And 2, that they do not punish them, that it's not a career ender. Those are the 2 things that have to be brought to the attention of the leadership. And when you have that culture and a bipartisan consensus supporting whistleblowers, I think that's the most important thing to protect them.
I agree with all that, Senator, and I would just say briefly that I think it's important for managers to understand the standard for whistleblower protection, which is if a whistleblower has a reasonable belief that she or he has seen a violation of law, an abuse of authority, gross mismanagement, or gross misuse of taxpayer funds, that's the standard for whistleblower protection. And so making sure that that is well and widely understood is vital. And then I think second and last, I would say for managers in the executive branch to see cooperation between OSC and the Congress is vital. And I commit to be a full partner to support the Congress and its protection of whistleblowers, and would look forward, if confirmed, to working with you, with this committee, and with your staff.
Very good. Well, I would like to thank both of our nominees for joining us today, and for your willingness to serve in these very important positions. The nominees have filed responses to biographical and financial questionnaires. Without objection, this information will be made part of the hearing record, with the exception of the financial data, which is on file and available for public inspection in the committee offices. The hearing record will remain open until 12 p.m. tomorrow, December 1st, for the submission of statements and questions for the record. This hearing is now adjourned.